The International Chamber of Commerce, or ICC, is a global business organization that promotes international trade and investment. Founded in 1919, the ICC has played a pivotal role in shaping the landscape of international dispute resolution. A cornerstone of its contribution is the ICC International Court of Arbitration, which administers arbitrations under the ICC Rules of Arbitration. These rules are a set of procedural guidelines that govern the conduct of international commercial arbitration. Widely recognized and respected, these rules offer a comprehensive framework for resolving disputes in a neutral, efficient, and enforceable manner. Parties from different countries and legal systems can rely on the ICC rules to provide a predictable and balanced process for resolving their disputes. The ICC rules have evolved over time to reflect the changing needs of the international business community. The latest version, the 2021 ICC Rules of Arbitration, incorporates innovations to enhance efficiency, flexibility, and transparency. These rules are designed to provide a fair and effective mechanism for resolving disputes, ensuring a level playing field for parties from diverse backgrounds. The ICC's commitment to promoting arbitration as a preferred method of dispute resolution is evident in the continuous refinement and adaptation of its rules. The ICC Rules of Arbitration stand as a testament to the organization's dedication to facilitating international trade and investment by providing a reliable framework for resolving cross-border disputes. The relevance of the ICC Rules of Arbitration remains high in the contemporary legal and business landscape, particularly in the context of international trade and commerce. Their adaptability and global recognition make them a preferred choice for resolving cross-border disputes. The ICC rules are designed to address the complexities of international disputes, making them particularly relevant for businesses engaged in cross-border transactions. The ICC has updated its rules to accommodate modern technologies, such as provisions for virtual hearings and electronic document submissions. This adaptability ensures the rules remain relevant in an increasingly digital world. The ICC Rules of Arbitration continue to evolve in response to the changing needs of the international business community, ensuring that they remain a vital tool for resolving complex international disputes. While the ICC Rules of Arbitration are widely respected and utilized, they are not without criticism. One of the most frequent criticisms is the high cost associated with ICC arbitration. The administrative fees, arbitrator fees, and legal costs can be substantial, especially for smaller businesses or less complex disputes. The discretionary power of the tribunal to allocate costs can sometimes result in unpredictability, with concerns that it may discourage parties from pursuing or defending claims. Despite the rule's emphasis on efficiency, some users find ICC arbitration to be time-consuming. Complex cases, particularly those involving multiple parties or extensive evidence, can drag on for years. There can be significant delays in the finalization and delivery of the award, particularly due to the ICC court scrutiny process, which, although intended to ensure quality, can extend the timeline. The rules, while providing flexibility, can also be seen as overly complex, especially for parties not well versed in international arbitration. This complexity can lead to misunderstandings or procedural missteps. The rules may be seen as too elaborate for smaller, less complex disputes, leading to calls for a more simplified set of rules for such cases. Critics argue that ICC arbitration may favour parties with more resources who can afford better legal representation and can handle the costs and complexities of the process more effectively. There is also concern that more experienced or powerful parties may have an advantage in selecting arbitrators or influencing the arbitration process, potentially leading to an imbalance. While confidentiality is a strength, it is also a point of criticism. The lack of transparency in ICC proceedings can lead to concerns about accountability and the development of consistent jurisprudence. In cases involving public interest issues, the emphasis on confidentiality can be problematic, as it may prevent public scrutiny and discussion of important matters. Although the rules provide mechanisms to challenge arbitrators for lack of independence or impartiality, successfully doing so can be difficult. The ICC Court's decisions on such challenges are often not explained in detail, leading to dissatisfaction among parties. There are occasional concerns about the selection of arbitrators, with perceptions that some arbitrators may be too closely connected to certain parties, especially in specialized industries or smaller arbitration circles. While the finality of ICC awards is often seen as a benefit, it is also a point of criticism. The limited grounds for challenging an award can be seen as problematic if parties feel that the decision was unjust or based on an error of law. The absence of an appeal mechanism within the ICC system itself means that parties who believe a mistake has been made have few options for recourse. The role of the ICC Court in scrutinizing awards and overseeing the arbitration process is sometimes seen as overly bureaucratic, adding layers of review that can slow down proceedings and add to costs. Some parties feel that the ICC Court's decision-making processes, particularly around arbitrator appointments and challenges, lack transparency and are too centralized. Although the ICC is a global institution, there is sometimes criticism that it is too Eurocentric in its practices, with a significant number of arbitrators and practices rooted in European legal traditions, potentially disadvantaging parties from other regions. While the rules provide for emergency arbitrators, their effectiveness is sometimes questioned. The enforcement of emergency decisions can be challenging, and the process may not always meet the urgent needs of parties seeking immediate relief. In complex, multi-party disputes, the rules can become cumbersome. The process for joinder and consolidation of related cases, while useful, can also complicate and prolong the proceedings, making it difficult to manage efficiently. The move towards virtual hearings, accelerated by the COVID-19 pandemic, has raised concerns about the ability of all parties to participate equally, particularly if there are disparities in technological access or expertise. There is also concern about the impact of virtual settings on witness credibility and the ability of arbitrators to assess evidence. In summary, while the ICC rules of arbitration are robust and widely respected, they face criticism related to costs, time consumption, complexity, potential inequalities, and issues with transparency and appealability. These criticisms highlight areas where users believe the rules could be improved or where they may not be the best fit for all types of disputes. The ICC rules of arbitration apply to a wide range of international commercial disputes. They are designed to be flexible and adaptable to different types of contracts and industries. The rules govern the arbitration process from beginning to end, providing a comprehensive framework for resolving disputes. One of the key aspects of the ICC rules is their broad scope. The rules can be applied to any dispute arising out of a contractual relationship, regardless of the nature of the contract or the subject matter of the dispute. This means that the ICC rules can be used to resolve disputes relating to, for example, the sale of goods, distribution agreements, intellectual property licenses, construction projects, and joint ventures. The ICC rules are also internationally applicable. They can be used by parties from any country and are not tied to any particular legal system. This makes them particularly well suited for resolving cross-border disputes, where the parties may come from different legal traditions and have different expectations about the arbitration process. To ensure the applicability of the ICC rules, the parties must include an arbitration agreement in their contract. This agreement is a crucial element, as it expresses the parties' mutual consent to resolve any future disputes through ICC arbitration. The arbitration agreement should clearly state the parties' intention to arbitrate under the ICC rules and specify any desired modifications or additions. Commencing arbitration under the ICC rules is a straightforward process designed to be efficient and transparent. The procedure begins when one party, the claimant, serves a request for arbitration on the other party, the respondent. This request formally initiates the arbitration proceedings and sets the process in motion. The request for arbitration is a crucial document that outlines the basis of the claim and the relief sought. It must include essential information such as the names and contact details of the parties, a brief description of the dispute, the applicable arbitration agreement, and the chosen seat of arbitration. The seat of arbitration is particularly important as it determines the legal framework governing the arbitration proceedings. Once the request for arbitration is filed with the ICC Secretariat, the ICC Court promptly scrutinises it to ensure compliance with the ICC rules. This scrutiny ensures that the request meets the formal requirements and that the ICC has jurisdiction over the dispute. After confirming compliance, the ICC Court will proceed to constitute the arbitral tribunal, marking a significant step in initiating the arbitration process. The respondent then has a specific time frame to submit an answer to the request for arbitration. This answer allows the respondent to present their perspective on the dispute, respond to the claimant's allegations, and raise any counterclaims. The respondent may also challenge the arbitral tribunal's jurisdiction or the validity of the arbitration agreement. The arbitral tribunal is the heart of the ICC arbitration process, responsible for adjudicating the dispute and rendering a final and binding award. The ICC rules provide for a flexible system for constituting the tribunal, allowing parties to tailor the process to their needs. The parties can choose to have a sole arbitrator or a three-member tribunal. In cases where the parties opt for a three-member tribunal, each party appoints one arbitrator, and the two party-appointed arbitrators then select a presiding arbitrator. If the parties fail to agree on the appointment of arbitrators within a specified time frame, the ICC Court steps in to ensure a timely constitution of the tribunal. The ICC rules emphasize the importance of impartiality and independence in the selection of arbitrators. Arbitrators are required to be impartial and independent of the parties, ensuring a fair and unbiased decision-making process. The ICC Court plays a crucial role in safeguarding these principles by scrutinizing the proposed arbitrators to avoid conflicts of interest and maintain the integrity of the proceedings. The tribunal's primary role is to conduct the arbitration proceedings fairly and efficiently. This includes setting the procedural timetable, determining the admissibility of evidence, conducting hearings, and ultimately rendering the final award. The tribunal has broad discretion in managing the proceedings, but must always adhere to the principles of fairness, due process, and equal treatment of the parties. Section 5. Conduct of proceedings, fairness and equal treatment. The conduct of proceedings in ICC arbitration is governed by the principles of fairness, due process, and equal treatment of the parties. These fundamental principles underpin the entire arbitral process, ensuring that each party has a reasonable opportunity to present its case and be heard by the tribunal. The ICC rules provide a framework for the procedural conduct of the arbitration, granting the tribunal flexibility in tailoring the proceedings to the specific circumstances of the case. The tribunal has the authority to determine the timetable for submissions, the language of the arbitration, the format of hearings, and the admissibility of evidence. Throughout the proceedings, the parties are expected to act in good faith and cooperate with the tribunal. This includes disclosing relevant documents, producing witnesses for testimony, and participating in hearings in a constructive manner. The tribunal has the power to impose sanctions for any failure to comply with its orders or for any conduct that obstructs the fair and efficient resolution of the dispute. The principle of equal treatment is paramount in ICC arbitration. Both parties must be given a fair and equal opportunity to present their case, submit evidence, and cross-examine witnesses. The tribunal plays a crucial role in ensuring that neither party is unfairly disadvantaged during the proceedings. Section 6. Interim and conservatory measures. In certain circumstances, parties may need urgent relief before the final award is rendered. The ICC rules recognise this need and provide for interim and conservatory measures to protect the parties' rights and interests during the arbitration. Interim measures are temporary orders issued by the arbitral tribunal to preserve the status quo, prevent irreparable harm, or secure the enforcement of an eventual award. These measures can include orders for the preservation of assets, the disclosure of documents, or the provision of security for costs. Conservatory measures, on the other hand, are sought from national courts before or during the arbitration proceedings. The ICC rules explicitly recognize the right of parties to seek such measures from national courts, even if the arbitration agreement provides for ICC arbitration. This provision ensures that parties are not deprived of their right to seek urgent relief from a competent court when necessary. The ICC rules strike a balance between the powers of the arbitral tribunal and the jurisdiction of national courts in granting interim relief. The tribunal has the authority to grant interim measures within the scope of the arbitration agreement, while parties retain the right to approach national courts for conservatory measures that fall outside the tribunal's purview. Section 7. Final awards and costs. The culmination of the ICC arbitration process is the final award, a binding decision that resolves the dispute between the parties. The ICC rules provide a clear framework for the rendering and enforcement of awards, ensuring finality and legal certainty. The arbitral tribunal is responsible for drafting the final award, which must be in writing, reasoned and signed by the arbitrators. The award must address all of the issues in dispute and state the reasons for the tribunal's decision. This reasoning is crucial as it allows the parties to understand the basis for the award and facilitates its enforcement. Once the final award is rendered, it becomes binding on the parties and they're obligated to comply with its terms. The ICC rules highlight the final and binding nature of awards, emphasizing that they are not subject to appeal or review by national courts except in very limited circumstances. The final award also addresses the allocation of costs, including the arbitrator's fees and expenses, administrative costs, and the parties' legal costs. The ICC rules grant the tribunal broad discretion in allocating costs, considering factors such as the outcome of the arbitration, the parties' conduct, and the complexity of the case. Section 8. Confidentiality in ICC arbitration. Confidentiality is a cornerstone of ICC arbitration, ensuring the privacy and protection of sensitive business information. The ICC rules recognize the importance of confidentiality and provide for safeguards to protect the parties' interests. All aspects of the arbitration proceedings are confidential, including the existence of the arbitration, the parties' submissions, the evidence presented, the hearings, and the final award. This confidentiality obligation extends to the parties, the arbitrators, the ICC Secretariat, and any experts or witnesses involved in the arbitration. The ICC rules strictly prohibit the parties from disclosing any information relating to the arbitration to third parties without the express consent of all parties involved. This confidentiality provision ensures that sensitive business information remains protected throughout the arbitral process. The confidentiality of ICC arbitration provides a safe and private forum for parties to resolve their disputes. This confidentiality is particularly valuable in cases involving sensitive commercial information, trade secrets, or reputational concerns. Section 9. Enforcing awards, the New York Convention. One of the key advantages of ICC arbitration is the enforceability of its awards under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, dating back to 1958. This convention, ratified by over 170 countries, provides a robust framework for enforcing arbitral awards globally. The New York Convention obliges signatory states to recognize and enforce foreign arbitral awards, including those rendered under the ICC rules. This means that a party seeking to enforce an ICC award can rely on the convention to have the award recognized and enforced in the courts of any signatory state. To enforce an award under the New York Convention, the parties seeking enforcement must typically provide the court with the original award, the arbitration agreement, and proof that the award has been properly notified to the other party. The Convention sets out limited grounds for refusing enforcement, such as public policy concerns or lack of due process. The New York Convention plays a vital role in ensuring the effectiveness of ICC arbitration. It provides parties with confidence that their awards will be enforceable across borders, fostering a stable and predictable environment for international trade and investment. Section 10. Historical evolution of the ICC rules. The ICC rules of arbitration have undergone several revisions since their inception in 1922, reflecting the evolving needs of the international business community and the changing landscape of international arbitration. Each revision has aimed to enhance the efficiency, transparency, and fairness of the arbitral process. The original 1922 rules laid the foundation for institutional arbitration under the auspices of the ICC. They introduced key concepts such as the role of the ICC Court, the constitution of the Arbitral Tribunal, and the conduct of proceedings. The 1922 rules marked a significant step in standardizing international commercial arbitration. Subsequent revisions, such as the 1975, 1988, 1998, and 2012 rules, introduced further refinements to the arbitral process. These revisions addressed issues such as the expedited procedure for smaller claims, the joinder of additional parties, the challenge procedure for arbitrators, and the increased use of technology in arbitration. The latest revision, the 2021 ICC Rules of Arbitration, builds upon this rich history of innovation. It introduces new provisions to enhance efficiency, such as expedited procedures for challenging arbitrators and provisions for early dismissal of unmeritorious claims or defences. The 2021 rules also address contemporary issues such as cybersecurity and data protection. Section 11. Step-by-step Guide to ICC Arbitration. Navigating ICC arbitration may seem complex, but the process can be broken down into a clear sequence of steps. Understanding these steps is crucial for parties considering or engaging in ICC arbitration. First, the arbitration agreement. The foundation of ICC arbitration is the arbitration agreement, a clause in the contract specifying the parties' agreement to resolve disputes through arbitration under the ICC rules. Second, the request for arbitration. To commence arbitration, the claimant submits a request for arbitration to the ICC Secretariat. This request outlines the dispute, the parties involved, and the relief sought. Third, the constitution of the tribunal. The ICC Court scrutinizes the request and, once deemed compliant, proceeds to constitute the arbitral tribunal. Parties can choose a sole arbitrator or a three-member panel. Fourth, the terms of reference. The tribunal and parties establish the terms of reference, outlining the procedural rules, timetable, and issues to be addressed during the arbitration. Fifth, written submissions. Both parties submit written pleadings stating their case, presenting arguments, and providing evidence supporting their claims or defences. Sixth, evidentiary hearings. Depending on the complexity of the case, the tribunal may hold evidentiary hearings where witnesses testify, experts present their opinions, and parties can cross-examine. Seventh, closing submissions. After presenting evidence, both parties submit closing submissions summarising their arguments and the evidence presented. Eighth, the final award. The tribunal carefully considers all submissions and evidence before rendering the final award, a binding decision resolving the dispute. Ninth, enforcement. If a party fails to comply with the award, the prevailing party can seek its recognition and enforcement in the courts of any country that is a signatory to the New York Convention. Section 12. Major rules in the 2021 ICC Rules of Arbitration. The 2021 ICC Rules of Arbitration represent the latest iteration in the ICC's commitment to providing a modern and effective framework for international dispute resolution. These rules introduce several key changes and innovations aimed at enhancing efficiency, transparency, and fairness. First, early case management. The 2021 rules emphasize early case management. empowering tribunals to take a more proactive role in guiding the proceedings. This includes setting realistic timetables, identifying and narrowing the issues in dispute, and encouraging the efficient use of technology. Second, expedited procedures. The rules provide for expedited procedures for smaller claims, aiming to resolve disputes more swiftly and cost-effectively. These procedures streamline the arbitration process and limit the length of written submissions and hearings. Third, third-party funding. Recognizing the growing prevalence of third-party funding in arbitration, the 2021 rules require parties to disclose the existence and identity of any third-party funders. This disclosure promotes transparency and helps ensure the independence and impartiality of the arbitral process. Fourth, joinder and consolidation. The rules streamline the procedures for joining additional parties to an existing arbitration or consolidating multiple arbitrations. This allows for the efficient resolution of related disputes involving multiple parties. Fifth, emergency arbitrator. The 2021 rules maintain the emergency arbitrator provisions, allowing parties to seek urgent interim relief before the constitution of the arbitral tribunal. This ensures that parties can obtain swift relief in time-sensitive situations. Section 13. The philosophy of the ICC rules party autonomy and neutrality. The ICC rules of arbitration are underpinned by a core philosophy that emphasizes party autonomy, neutrality, and efficiency. These principles are central to the ICC's vision of arbitration as a preferred method for resolving international commercial disputes. Party autonomy. The ICC rules recognize the importance of party autonomy, allowing parties to tailor the arbitration process to their specific needs. This includes choosing the arbitrators, the seat of arbitration, the language of the proceedings, and the applicable law. Neutrality. Neutrality is paramount in ICC arbitration. The ICC court and the arbitral tribunal are independent and impartial, ensuring a level playing field for parties from different legal systems and cultural backgrounds. The ICC's commitment to neutrality fosters trust and confidence in the arbitral process. Efficiency. The ICC rules are designed to promote the efficient resolution of disputes. This includes setting clear timeframes, encouraging the early identification and narrowing of issues, and providing for expedited procedures for smaller claims. Confidentiality. The ICC rules recognize the importance of confidentiality in international arbitration. All aspects of the proceedings are confidential, protecting sensitive business information and fostering a safe and private environment for dispute resolution. Enforceability. The enforceability of ICC awards is a cornerstone of the system. The ICC's commitment to enforcing awards under the New York Convention provides parties with assurance that their rights will be protected and their awards will be enforceable globally. Pause 3, S Section 14, Practical Tips for Parties. Engaging in ICC arbitration, Pause 2S, while understanding the principles and rules of ICC arbitration is crucial, knowing how to navigate the process effectively can make a significant difference in achieving a favorable outcome. Here are some practical tips for parties engaging in ICC arbitration. Select arbitrators with expertise relevant to your dispute. Their knowledge can provide valuable insights and expedite the resolution process. Ensure that the chosen arbitrators are independent and impartial, free from any conflicts of interest that could affect their judgment. Clearly specify the seat of arbitration, applicable law, language, and procedural rules in your arbitration agreement to avoid ambiguity later on. Customize the arbitration agreement to reflect the unique needs of your dispute, including any special procedures or timelines. ###3. Gather all necessary evidence and documents early in the process. Being well prepared can significantly strengthen your case. Engage experienced legal counsel who understand the intricacies of ICC arbitration and can guide you through the process effectively. Don't hesitate to request interim or conservatory measures if you need immediate relief to protect your interests before the final award is issued. Use interim measures strategically to maintain the status quo or prevent irreparable harm. Work with the arbitral tribunal to adopt efficient case management techniques, such as agreeing on a procedural timetable and narrowing down the issues early on. Embrace modern technology, including virtual hearings and electronic document submissions to enhance efficiency. #6. Reinforce the confidentiality obligations in your arbitration agreement to protect sensitive information. Ensure that all parties and witnesses understand the importance of maintaining confidentiality throughout the process. Be aware of the potential costs involved, including arbitrators' fees, administrative expenses, and legal fees. Budget accordingly to avoid financial surprises. Consider using cost-effective measures, such as expedited procedures for smaller claims to manage expenses effectively. Ensure that your arbitration agreement and final award comply with the requirements of the New York Convention for Enforceability in over 170 countries. Understand the limited grounds for challenging an award and prepare for the finality of the arbitral decision. Pause 2S. By following these practical tips, parties can navigate the ICC arbitration process more effectively, ensuring a fair, efficient and successful resolution to their disputes. Pause 3S. This concludes our comprehensive guide on ICC arbitration. Stay tuned for more insightful content on international dispute resolution. See you in the next video.